And welcome to Justice Serve TV. Today, Monday, Columbus Day for those who celebrate such. Will justice be served in the case against Donna Adelson? Today is sentencing. We are live.
Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And hello there, Michael Bryant here. I said we are live, kind of in the royal sense. Linda Kenney Baden is on assignment, so she will be joining when we have our regular show tonight at 6 o'clock. But for now, you're stuck with me. So what we're going to do is, I assume that Judge Everett is going to be on time, as he has been. I know we had the seal up there showing that they do have a feed coming from the courthouse, from the courtroom. 3G, as I recall. But I don't expect him to be, killing time waiting for this to get going. So assuming that is the case, I thought we'd just hit on a couple of things before we go into court for the actual sentencing. I know there's a lot of discussion about, is Donna Adelson going to make a statement? What? First of all, we have to know and acknowledge that it doesn't matter what she says. It doesn't matter what anybody says. The court has the requirement to impose life without the possibility of parole. It is a conviction on murder. That's done. It's a done deal. And people might be saying, why did they delay sentencing? And why? Well, remember, there were two other charges. There was solicitation and conspiracy, both of which she was found guilty, both of which, aside from the murder conviction, would be in the system for possible probation down the road, right? So there's a pre-sentencing, some call it a report, some call it an investigation. Anyway, it's a document that tells the court what the investigation has shown. It looks at priors, it looks at life history, it looks at relationships, it looks at all the things that might affect whether a given defendant should someday be released, and if so, what's the support system look like for that person? Well, obviously, it doesn't mean squat in this case because she ain't never getting out. But again, you've got two lesser included charges. What if this goes up on appeal on the top charge and it's reversed and remanded and somehow she's ultimately exonerated? Then those other two are still alive, right? Unless they all get lumped into any sort of reversal and there's a total exoneration. I'm hearing the noise of the courtroom, the shuffle. So I'm hesitant. I can't believe they're going to start this early. So if they do, obviously we will pop right in there. But before we do that, I wanted to refresh everybody's recollection, about this pre-sentence investigation. That was received by the court, and the court, sua sponte, moved the hearing for the sentencing from tomorrow up to today. Remember, that application of the report will apply to the two charges that she's convicted of, conspiracy and solicitation. So we'll hear that. We'll hear that maybe she's sentenced to 15 years on conspiracy or 20 years on solicitation. And so in theory, at the end of her life sentence, if that's not reversed, she'll get out after her life sentence. Does it make sense? They have to go through the steps, even though it seems a little bit bizarre when you've got a top charge that means the defendant ain't ever getting out. Okay. But that's what they'll do. And that's what we hear today. You'll hear some verdict, some sentence on those other two verdicts, even though in all likelihood they will never come into play. Now, so while we're waiting for the judge to take the bench, this may refresh your recollection.
As follows, as to count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
Yeah. So if you missed that, if you needed a little refresher there, that's what that day was like. And remember, let me see if I can find this because the contrast was amazing in my mind. 24 hours before that moment was the last day that she was transported to court for what was then going to be closing arguments and the beginning of jury deliberation, right? Jury deliberation, as you'll recall, began on the 3rd and then slopped over into the 4th, at which the decision was actually made. And so when I obtained all of the body camera footage from the day before and the day after, which was fascinating in and of itself, comparing those two periods of time side by side, as I've said many times, what a difference a day makes, 24 little hours. It looks kind of like that. If you haven't seen this side by side before, that's there she is, Donna Adelson, heading to court with her beat up folder that nobody would give her a new folder. They wouldn't allow her to have staples because she would staple herself to death. I'm not sure I would staple a guard to death. So they wouldn't let her have staples. So she was trying to kind of tape the spine of that folder, which has all of her precious information in it. So there she goes. She's kidding with the guards. It's just yucks all day. And then on the right side, we have her being wheeled backwards through the interlocking doors of the jail and off into Never Never Land for the near future. That was again on the 4th of September. Here we are a month and 10 days later, a month and 8 days later. As you know, as a result of getting this material and a lot of the other stuff from Leon County, they were very nice at preparing a lot of stuff for me. I got the latest phone logs and visitation logs. So I'm going to look through some of this now with you, and once we hear the court jostle to life, we'll jump in there. Hey, a lot of folks have noticed, my friend, the skeleton Bonesy, back over my shoulder here, gone today. Well, it's Halloween time, so Jonesy has things to do. He's got appearances to make. He'll be back after the holiday. In the meantime, I do have this. Went to the pumpkin patch this weekend. Check this out. This is the official JSTV pumpkin. I don't know, is a green pumpkin because it's just a not ripe pumpkin. I mean, I'm not a horticulturist. I'm not a farmer, but I think it just means it's not ripe. When I saw the green one, I thought that looks like Justice Serve TV green. Look at that. Look at how well that meshes with our logo. So that I'll put that on the back there, and it'll hold Bonesy's place for a while. Okay, so how many visitors? Remember, she's in. Let me make sure I get the room right because the room has never changed. It is medical room 520. She's been in that room since September 4th when she was wheeled back in, as we saw in that photo a second ago. And that's primarily for her own safety because there's some concern the court had that she would self-injure herself. Although, I don't think she has the guts to injure herself. She does have the guts apparently to hire somebody to injure somebody else. I don't think she's got the guts to injure herself, but that's the thing. So we believe that because of that, and I've called the jail, but I've gotten no official response. We believe that because she's in that level, that type of custody, that visitors are not allowed. So the latest log confirms that she has not had not one visitor officially since the day she was convicted. Phone calls, oh boy, that's a different story. I won't bore you with how many we went over before. I mean, there were hundreds, and there are hundreds again. This is the period from the end of September, because I just basically kept asking for them sequentially. I think this was from September 28th through last Friday. So couldn't get the weekend, obviously. I'd have to ask for those today. And it's odd that they moved this up to Columbus Day. Who celebrates Columbus Day? Raise your hand. Yeah, I know there are a few folks. I know Linda Kenney Baden, although I know she's working today on assignment. Normally, it's a very strong Italian holiday here in the Northeast. In California, when I was growing up and living there forever, it's like, what? Oh, we get another day off of school. Back when I was a kid, that was great. But it never had any significance beyond that. Here, there's a parade in New York, and in the Northeast, it is a huge thing. Not so much in Tallahassee because they moved the hearing from yesterday. That's actually why I thought they had it set up for the 14th tomorrow instead of today, because they were respecting the holiday, but no. Thank you, Brooklyn 10952. Appreciate you becoming a member. And so this holiday is it's a weird holiday. I'm just not sure exactly, where it fits in the mix. Madeira Beach caregiver, always so generous, and we're so glad to have you along. Hip hip hooray, Despicable Donna getting the boot today. This now moves quickly on to Wicked Wendy's arrest. Many people have theorized, and it's as good a theory as any, that until Donna would be sentenced, and the conviction actually sets, think of it as concrete. Think of it as slow-drying concrete as a DIYer. You pour the concrete the day of the verdict, right? And then it just starts to set up. But it's not truly a conviction until you're sentenced. Okay. And there are some cases where that becomes very frustrating. You, of course, know the Durst case out of California, who was finally convicted in all of his shenanigans. But then he was so sick. I mean, I was waiting for the day in court where he was wheeled in a gurney, not just a wheelchair. And I think, I may be wrong, but I think there was one point in which he was. Tubes coming out of him. You know, he had like a massive scar on his head where they had opened it up for whatever purpose. Anyway, so he dies before he's sentenced. Therefore, Mr. Durst was never convicted of the crimes for which he was tried, and a jury pronounced him guilty. Nope, he went to his grave. Most think downward from there, not upward, but he went as someone not convicted of murder. So that's what today does. So it starts the clock on appeals. It starts the clock on, I believe, and many do, Wendy's freedom. Just seems that from what we've seen from the prosecution all along, Sigfredo Garcia, Luis Rivera, Catherine Magbanua, Charlie Adelson, there she is. She's wearing purple today. Are those might be her jail togs, though? Hard to tell. She has no incentive, really, to dress any differently, or they may not even allow her to dress any differently today than the togs. So anyway, all of those timings, the clock begins today once sentence is pronounced. Harvey looking sharp. He never wore a suit and tie to the trial. It was always much more casual, Florida jogging suit kind of attire. I'm guessing it's packed. And most people are wondering, is she going to say anything? Well, I don't know. Get anything from the image of seeing her there? Is she just resigned to it? That there's nothing she can do? It's a fait accompli. That's the reality. But she's been deluded before, so maybe she does want to say something. A lot of folks were, surprised. She filed a motion for a new trial, and typical pre-sentencing motions. But they're never, an attorney's going to, in good faith, try to make those things stick and hopes for some positive outcome. But no, it's really done just to preserve those issues for appeal. You can't begin the appellate clock until sentencing. And in most states, it's 30 days. So once the sentencing is pronounced, you have 30 days within which to file a number of post-trial motions. Sometimes appeal timetables lengthened a little bit, depending on the jurisdiction. But again, there is no time frame until today, until that conviction sets, as the concrete sets. You can walk on, let's put it this way, you can walk on the conviction today. How about that? Before this, it's not quite set up. It's still a little mucky, a little mushy. But today you'll get to walk on the cement that is the conviction. So as we're waiting for this, let me just hit a couple of high points from these records. You know what Harvey's doing almost every day, at least based on these records? Talking to Donna. Yeah, 4 hours. And I don't mean 4 hours. I mean 4 hours. Let me just give you one example, okay? On September 25th, I guess I started these later in September. I thought it was 28th, but 25th, I have records showing 7 calls, a total of more than 5 hours on the phone with Donna between the hours of 9 a.m. and 9 p.m. And I'm guessing that's the parameters they give her, because I can't imagine she's waiting. If they say go, she goes. So here's Harvey's day all day. I know. I'm sorry. Yeah. I think he's on the listening end of hour after hour of babying, crying, woe is meing. Let's see what else we had on the phones here. A lot of calls to Jackie Fulford. Of course, we know she is one of co-counsel. 40 calls to her. 40 calls. There were a total of 115 complete calls, 172 total calls. So do the math for me. Do the math. Was that about 50-ish, 57 incomplete calls? And that can be for many reasons. Somebody just didn't answer. Somebody didn't accept the call. And the cost? Oh, let's go to the cost.
All right. Session on
Let's go into court.
Afternoon, everyone. You can see that.
looks kind of resigned to me. Just kind of like, can we just get this over with?
Is your Zoom open or are you working on that?
I'm signing into the computer right now.
Okay, they're talking about opening up the Zoom lines. That may mean there's some statements from others. So you saw Jackie there with her again. She had 40 calls with Jackie over that 2.5-week period for this set of phone records. And it wasn't daily, it was in bursts. And there was one call again to Mr. Zellman. Remember the last time we went over the records, there was one call to Mr. Zellman. There was also one call in this case to Mr. Zellman for this period of time. And then there's some other calls that you guys could probably help me figure out, because I did some searching, couldn't figure out the connection or why. One person with 13 calls, another with 5, both in the North Carolina area. I know there is a connection there, but it's not as direct as I can recall. Ann Cunningham, remember her friend Ann Cunningham? One call. Just one. That was later in this period.
The defense had a witness that was going to be giving a statement over Zoom this afternoon.
That's correct, Judge.
Is there anyone that is going to be attending on behalf of the state as well?
Yes, Your Honor. The Markel family will be appearing by Zoom, but they're relying on their statements previously made.
So obviously we heard from Ruth Markel, Mr. Markel, at the day of conviction where they were tossing about whether or not to have sentencing. So it sounds like they'll be there listening in, but not making an additional statement, just relying on what they've already done.
I won't read the phone number out loud, but his iPhone, one of the witnesses in this matter.
I believe the gentleman appearing is our witness, Judge, his case.
Judge, the 647 number belongs to Mrs.
You can tell her to rejoin.
Wilson.
I think Harvey's wondering, what if? Am I? Is it me next? What is going through his head? Yeah, I'd be taking deep breaths too.
If everyone on the Zoom can keep themselves on mute until it is time for you to speak, please. We're here this afternoon for final disposition and sentencing in case number 2023 CF 3226, State versus Donna Adelson. Parties can make their appearances.
Georgia Kappelman for the state.
Joshua's on for the defense.
Jackie Colford on behalf of Mrs. Adelson.
Have the parties received their copies of the pre-sentence investigation report?
Yes, Your Honor.
Yes, Judge.
Are there any objections that either party wishes to make to the pre-sentence investigation report?
No, sir.
There are corrections that would need to be made, Judge.
What are the corrections?
Would you like me to stay in here at the length?
It's in there.
On page 1, they have the date of arrest as November 20th, 2023. And she was actually arrested on November the 13th of 2023.
I will notate the, Ms. Kappelman, is there any
No,
challenge to those?
No, sir.
I will notate the copy then that will be filed with the clerk as November 13th of 2023. Go ahead.
On page number 5, there are several. The first place, near the top, it says wage salary, and this was supposed to be her current employment that she had, and it said $1,000. She did not have employment where she made $1,000. She was not receiving any salaried income, so that should be 0.
Ms. Kappelman, do you wish to be heard concerning those?
No, Your Honor.
So again, I will notate the wage salary as $0.00.
Thank you, Judge. The next, underneath there, it says the number of jobs in the past 2 years, 1. She has had no jobs. She's been employed the majority of the 2 years.
Which part of page 5 are you referring to?
Well, that's on page 5, right underneath the wage.
So no jobs, no employment.
Correct, that should be 0.
Ms. Kappelman, do you wish to be heard?
No, sir.
Notate that there has not been any employment or 0. Go ahead.
Thank you, Judge. Directly under there, it says months unemployed in the past 2 years, 0, and she's been unemployed for 2 years.
Well,
No objection.
so you're asking for that to be 24 months.
Correct.
Go ahead.
There are 2 typographical errors in the remarks section. The second line from the top in the remarks says history, comma, she. I believe that's supposed to say the defendant.
Give me one moment, I'm finding it. You said history is the first word leading into the correction.
History is right next to the word she. You see that's on the second line down. It says remarks, and then the word right under there on my copy says history, comma, she.
Yes.
It should be the.
It's Kappelman.
No objection.
Go ahead.
And then in the same paragraph, 4 lines down to the far right, it said who had fallen in. That should be ill, I-L-L.
No objection, Judge.
Go ahead, Ms. Wolford.
Yes, sir. Going down under the financial status to where it says estimated total debts, in the second line, it says a second mortgage was taken out to pay for their home. That should say legal expenses, not home.
No objection.
Go ahead, Ms. Wolford.
Yes, sir. The same section where it states remarks, 3 lines down, it says husband's dental practice. That's incorrect. The dental practice was not providing income prior to her arrest. She was only receiving Social Security assistance.
You're just asking husband's dental practice to be scratched through.
That's correct. The only income was, they listed Social Security, but they listed both.
No objection.
Well, anything else?
On page 7, Your Honor, about halfway down the page, it has the remarks section. And if you go 1, 2, 3 lines from the bottom where it's listing grandchildren, on the right, it has a child's name, 14, and then it says a female, 7. That's actually a male.
No objection.
Right. Any other objections?
Not from the defense.
The court has reviewed the PSI report, and at this time I will direct the clerk to file it as a part of the record. Ms. Kappelman, do you have any other witnesses or evidence that you wish to present as a part of your presentation today?
I have some documentation regarding cost of prosecution, Judge. Would you like that at this time?
Yes.
The state has put together a summary page and a thumb drive. We are requesting $723,123.68 in restitution. Defense advised that they wanted supporting documentation regarding this request, which is contained on this thumb drive. They're just receiving it today. So have not had an opportunity to review it. I think at this time the parties are in agreement to ask Your Honor to order cost of prosecution and reserve regarding the amount, and we'll see if we can reach an agreement regarding the amount.
Very well.
So that's one item that's in dispute for today. Another issue, Judge, is the score sheet. I've prepared 2 score sheets. May I approach again?
You may.
First includes death points, bringing the lowest permissible prison sentence in months to 172.5. The second does not include the death points, bringing the lowest permissible prison sentence in months to 82.5. Brought to my attention yesterday that the defense objects to the inclusion of the death points. The limited research that I've had an opportunity to do suggests that they should be included if the death was a direct result of the crime. I believe it was. The defense wants to argue otherwise, so whichever score sheet Your Honor chooses to go with, they're both provided there for you. The state is requesting, are you ready for me to argue what I want for sentence? Okay.
Go ahead.
Obviously, life on count 1, Judge, we would ask for 30 years consecutive to count 1 on count 2, and 30 years concurrent to count 2, but also consecutive to count 1 on count 3. I do not have any additional testimony or other evidence to provide, Your Honor.
We've had this issue of the death points being attached to the non-homicide offenses come up in other cases. Certainly the death points would attach if there were an offense that were being scored, but the first-degree murder is not being scored on the score sheet. What would be the basis, Ms. Kappelman?
That the death resulted from the conspiracy. It wasn't just a conspiracy without a death. It was a conspiracy that directly resulted in a death, hence the death points are appropriate.
What is the defense's argument concerning the score sheet?
I'll do my best, Your Honor, to know the weather for the last week or so. It's the same argument that was made on behalf of Dr. Adelson post-conviction. Your Honor, granted the correction of the score sheet. Solicitation and conspiracy do not require an actual death. And I'll just rely on the same cases that were relied on by Dr. Adelson. State versus Johnson, 561 Southern 2nd, 1321. The crime, quote from that case, the crime of solicitation is completed when the actor, with intent to do so, has enticed or encouraged another to commit a crime. The crime need not be completed. And then in Becky v. State, 423 Southern 2nd 417, second DCA, crime of conspiracy consists of two necessary elements: an agreement, one, and two, an intention to commit the offense. Once the intent is formed and the agreement is made, the conspiracy is complete. Just like Your Honor did in Charlie Adelson's case, by order that was not opposed by the Attorney General's office. I believe that order is dated January 24th, 2025. Your Honor agreed with that position and ordered the state to prepare a corrected score sheet without data points.
Ms. Keppelman, my memory of this is in line with the defense position. Certainly, if the state wishes to take any appeal concerning the score sheet, that is your choice.
Understood, Judge.
Death points will not be added to the score sheet that is signed by the court. Is the defense ready to proceed with its presentation?
Yes, Judge.
You may proceed.
Thank you. Would you like me here or at the podium?
You may remain at the table, or you can come to the lectern, whichever.
Okay, thank you, Judge. I guess we would start with the witnesses that we have. The one that's standing by on Zoom is Dr. Ben Graber, who would like to make a statement on behalf of Mrs. Adelson.
Dr. Graber, if you at this time can please turn on your microphone. Please raise your right hand, sir. Dr. Graber, if you can raise your right hand to be sworn. Do you swear or affirm the testimony you're going to provide today will be the truth? I believe you have a volume problem, Dr. Graber. I can see your lips moving, but I can't hear you. I guess just so I can test that we do have proper audio, Dr. Graber, before you get started, Mr. Markel, if you can turn on your microphone and say 1, 2, 3 for me so I can test this audio. All right, he's not coming through either. Time to troubleshoot.
Yes, but I didn't know what I was supposed to be doing.
Right. Dr. Graber, if you can say 1, 2, 3 while I test this equipment. All right, I can hear you now, but we can't get him over the loudspeaker. At least someone must have switched the audio settings. My mic's fine. It's the witnesses need to be heard.
Yeah, they never had to deal with this in Perry Mason.
Right. Thank you, Mr. Markel. I'm going to place you back on mute at this point.
Sibilance.
Right. Dr. Graber, try to talk for me one more time. 1, 2, 3.
1, 2, 3. 1,
There
2,
we go.
3.
Judge and a Radio Shack, man, all in one. All right.
It's working?
It is. Let me swear you in again, sir. Please raise your right hand. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your head. If you're examining the witness, or is he reading a statement?
He's going to present a statement, Judge.
Dr. Graber, you may proceed at this time.
Where's the Geek
Thank
Squad?
you, Your
meeting?
Honor. I appreciate the opportunity to come and speak on behalf of Donna Adelson. If I can, let me just brief description of who I am, my background. I've been a friend of the Adelson family since 1979. First 20 years I knew them, we were actively engaged in many activities. The last 20 years, I haven't seen them that much until this trial became apparent to me. And my background is I'm a medical doctor practicing obstetrics and gynecology, 45 years here in Florida. I was also a state legislature from 1988 to 96, representing Coral Springs and parts of Broward County. I was the county commissioner in Broward County and mayor of Broward County for 1 year in 2006. Also a professor at the University of Florida Medical School and the University of Miami Medical School in clinical OB/GYN. And I'm here to speak today on behalf of Donna Adelson, the person I've known for a great deal of time. Hi Donna, just want to say hi. I'm sorry I can't be there to hug you. And I'm sorry we didn't get to have that dinner after your trial was over. But I'm here to, on your behalf, to let you know that you have friends, and I believe in you. Let me say that, Don, I never thought we'd be here at this situation when I first met you. It was a total shock to me and to our families. And it's a tragedy for me to have to be here to talk about this. I feel very bad for your family, for the Markel family, for the tragedy everyone's experiencing. To me, I've been following this for 2 years. It appears to be a dissolution of two families. My background is similar in many ways to both families. Like Ruth Markel, I'm the son of Holocaust survivors. I actually was born in Germany at displaced persons camp. Came to the United States at the age of 18 months. So like the boys, Lincoln and Benjamin, I don't have a lot of recollection from the first beginning of my time in the United States, where they don't have the recollection of their father, which is very sad to me. But they do have families, and I had family. And we have to learn a great deal from our tragedies how to come back into life. My distress is not just for Donna and the Adelsons, but for the Markels as well, and especially for 3 generations of each family, which I see in tragic downward swing. And yet, I did meet Lincoln and Benjamin at the bar mitzvah last year, and I got to meet those 2 boys, wonderful boys. Unfortunately, I never got to meet Dan Markel, but I have read many of his articles. Very impressive, very brilliant, very talented man who made some very good points about the law and about compassion in the law, which he felt could be improved. And I agree with that. So part of what I'd like to say today is basically that I do believe that Donna is a victim of not just circumstance, but has been actively exploited by parties involved in this case. I believe she was exploited by her son. Knowing Donna, who was the youngest child in her family, and knowing her mother, and how close she was with her mother, and understanding their love and need for family, it makes no sense to me that she would pursue an activity that will destroy 2 families like it has. However, having known her son and some of his issues, I believe Donna, in her own naive way, trying to be a loving mother, is subdued by guilt, by silence, by denial, and perhaps even active exploitation, and used for activities she had no part of. So I believe she's innocent on all 3 counts, even though she was found guilty on all 3 counts. Part of my understanding is also that the victims here are both families, and to watch the hate and distress and the vengeance I see is a terrible thing to look at. As Holocaust survivors, you'd think we would understand that better, how damaging it is to families. I would have to say, my background, I grew up in the Bronx, went to the public school system. I actually was at Queens College when Donna was there, but I didn't know her. She graduated a year after I did. My wife Sandy graduated from Queens College as well. In Coral Springs, we met up after being there a while, new young families, professionals trying to build a life, having children, building the community, which we did. So to see this situation occur, to me, is devastating in many aspects. As a legislator, I can tell you that we see things in law. Even though I'm a doctor and I was chairman of healthcare, I was a Democrat, majority leader, and I sat on the Judiciary Committee for 2 years, and understood how the laws. Even wrote some of the sentencing guidelines and participated in passing them at that time. What I learned over the years was that I had the privilege of passing many laws, because I was a leader and was able to work both sides. And so many of my laws exist in the books. I get calls from judges periodically asking me about the intent of the law when I wrote it, because they have a case and it's come down to what did you intend to happen from this law. And they would ask my opinion, and they would use that information. So I'd like to look a little bit about the intent of the judicial guidelines for sentencing. I think the life without parole is a very harsh sentence. And that was not the intent, was to punish domestic cases with that, but to hit drug dealers and organized crime and dangers to the public. But I think it's been switched over to be used in conspiracy theories against the average citizen, which is not the intent of the law, in my opinion. Second of all, I think that it's unfortunate that this case has gone into so many new victims. And we've already, you have 4 victims who have been found guilty of murder. 2 have committed the murder, maybe 1. The others are conspiracy theories. And I would believe that I would suggest that that needs to be reviewed by the legislature. That's my opinion. Now, in this case,
Dr. Graber, before you continue, is this being offered as character? Because he is not an expert on the law.
It's character, Judge.
Very well. You may continue, Doctor.
Yes, that's my opinion from my background. It's not, I'm not giving a professional opinion. I'm giving my personal opinion from experience. What I'm asking the court today is, to me, the court, the judicial system, the power of the judicial system is in the judge. And it is the judge who is the presenter or the safety net for the public to show some compassion when the cold written law, with every box checked off, shows no compassion. Where does the compassion come from? It should come from the judge, or should come from the jury. And I think that maybe that's something we have to consider. So at this point, what I'm saying is that I believe Donna Adelson is a 5-star mother, did everything she could do for her kids, for her family, for her community. She has no bad intentions. She's not a leader, she's a baby in her family. She's always been a follower. Yes, she makes noise and she complains, but that's not her behavior. This is not her profile. So I understand that nothing can be changed, but I want to put on record that I believe she is innocent of these 3 counts, and we believe her. With that, I would have to say, sometimes bad things happen to good people, and I think this is one of those cases, and it's unfortunate. For the families, I would ask, beg them, think about the 2 boys. Dad is not here, but a piece of him is here, and those 2 boys. And their future, they're both teenagers now, their future depends a lot on what's going on here, and how they're going to be perceived in the future, and how they will interpret the future. based on this. So I think it's time for some compassion, some understanding, some forgiving. Perhaps it's time to take a step back and let everyone heal from this process. With that, I say to you, Donna, Samuel and I love you. We support you and the family, and we hope you the best. God bless you. And Your Honor, thank you for letting me speak.
Defense have an examination for the witness?
No, Judge.
Does the state have an examination for the witness?
No, sir.
Dr. Graber, you can remain on the Zoom. I would just ask you to mute yourself at this point.
Thank you, sir.
Defense have any other witnesses to present or evidence?
Yes, Judge. We have Rick Chagrin, who's present, who would like to make a brief statement.
Please raise your right hand, sir. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You can lower your hand. You may direct the witness or you may give a statement.
If you could state your full name, please.
My name is Richard Gordon Chagrin.
And have you prepared a statement here today?
Yes, I have.
Okay, you can give that to the court at this time.
This is on behalf of myself and my wife Susan Brotman, an attorney at law. We have known Donna Adelson for over 35 years. She's been a dear friend and travel companion, and we are still in shock of her current circumstances. We know her to be a loving parent, wife, and grandparent. We stand behind her claim of innocence. We feel the trial was held in a county where there's been a lot of bad and inaccurate negative publicity, therefore not allowing a fair trial. We contend if a change of venue was granted, she would have been found not guilty. We are hopeful she will be relocated to South Florida, where she can pursue all legal remedies available. Thank you very much for your consideration.
These are character statements or quibbling about the evidence and the rulings?
It's character, Judge. They're here to talk about their friendship and time. Thank you.
Any witness examination for Mr. Chagrin?
Scotty?
No, Your Honor.
You may be seated. Any other witnesses?
We did provide to the court, if you received your copy, Judge, some very short letters that were written as character support on behalf of Mrs. Adelson, if I may go through those at this time.
Go ahead.
Thank you. The first letter that was submitted to the court was by Annie Cunningham and Ronald Gutterson, who testified at trial. They say, "We are writing this letter to restate our knowledge and feelings regarding Donna Adelson. We have known Donna since 2009 and consider her to be our dearest friend. Donna is a kind, caring, loving person. She was always concerned with the welfare of others. She is not the monster portrayed by the media. Donna is incapable of threatening or harming anyone. Donna is almost 76 years old and in frail health after almost 2 years of incarceration. We will always believe her to be innocent and ask the court to take these factors into consideration when deciding Donna's sentence." Next, we submitted to the court was one of her longtime friends, Ruth Rosenberg, who wrote, "I immigrated to the USA from Israel when I was 1 month shy of 12. I lived in Israel in a town of 5,000 inhabitants where my family knew almost everyone and came to New York City, Queens, with a population of close to 8 million residents. To say it was a culture shock is an understatement. I didn't speak any English and physically looked like an underdeveloped child in comparison to the American girls my age. I entered the 7th grade in September, not knowing any English, the, quote, stranger in school. For several months, I sat by myself at lunchtime in the cafeteria, staring at the next table, where Donna and a group of her friends were conversing, laughing, and having a nice time. One day, Donna walked over to my table and asked me if I would like to join them, and of course I said yes, please. That kind gesture started a 62-plus year friendship. She invited me to her house to meet her family, and over time we became like sisters. I can recall several instances where Donna helped me obtain a job so I can help my parents financially. She introduced me to a family in a bungalow colony in the Catskills who needed a mother's helper for their daughters in the summer of '66. The money I earned helped my parents pay for the closing costs on their house. The following summer, she got me a job as a counselor at Camp Allegra in the Berkshires. When I had to decide on a career path, I consulted with Harvey and Donna about applying to dental school as my college advisor had recommended. Later that year, I was chosen to be the maid of honor at their wedding. We remained close friends throughout the years, even though we lived more than 1,000 miles apart. Our families visited each other periodically, making sure that our children and grandchildren got to know each other. We attended life cycle events of our children, bat and bar mitzvahs, weddings, special birthdays, etc., and now our grandchildren's. Donna has always been a kind-hearted, generous, loving, and caring. She is one of my best friends, and I will forever remember and appreciate how she helped me with English while I helped her with math in Parsons Junior High School, and remained loyal through these 62-plus years. The situation she is in today is unimaginable to me. That is not the person I know and love. We also submitted a letter from Ron Ellis to the court. My name is Ron Ellis, and I have had the privilege of knowing Donna Adelson for more than 30 years. I am writing to you in hope of offering some perspective on the woman I have come to know so well over the course of our long friendship. Donna has been a steady and caring presence in my life. When my stepson passed away 11 years ago at the age of 34, Donna was there for me in ways I will never forget. She sat with me in my grief, listened when I needed to talk, and offered comfort when I felt overwhelmed. That kindness and empathy is the Donna I know. Someone who shows up for her friends and offers strength in their darkest moments. Over the years, I have seen Donna's compassion extend beyond just me. She has been a devoted mother, a loyal friend, and someone who consistently tried to bring warmth and generosity to those around her. I understand fully the gravity of the situation before the court, but I hope that when you consider Donna's sentence, you will also weigh the years of kindness, care, and humanity she has shown to others. I believe that Donna still has the ability to contribute positively, even under these circumstances, and that she is capable of reflection and growth. I respectfully ask that you take these qualities into account when you make your decision. Thank you for your time and consideration. Respectfully, Ron Ellis. And then a brief letter from Marion and Tim Schaffman. She writes, we have known Donna for over 50 years, and although we live far apart and have seen her often over the years, we wanted to share with you our impressions of the lovely person we have known. Donna has always been a loving, kind mother and wife, and also an exemplary daughter to her parents, who often stayed with their family. We have never heard her utter a negative word about anyone, and had tremendous pride in every member of her family. She retained many friends from her childhood and developed long, satisfying friendships with the new people she met throughout each stage of her life. Donna was always intelligent, charismatic, and sensitive to everyone. She always listened to anyone's problems and offered a helping hand when she could. Most notably, her genuine concern over our and others' health issues was truly appreciated. As you can see, it is very difficult for us to view her as anybody other than the sweet, caring person we knew. Sincerely, Marianne and Ted Schaffman. Next is a letter from Jessica Ussery. Dear Judge Everett, my name is Jessica Ussery, and I am writing this letter to express my personal experiences and knowledge of Donna Adelson's character. Donna and I share a beloved grandson, Roman Harvey Adelson, born in 2017. My first memory of Donna is a video made and shared on Mother's Day 2017. Charlie Adelson surprised his mom with the news that he and my daughter Brianna were expecting a baby. It warmed my heart to watch Donna's genuine excitement and happiness caught on video. Our families began spending time together as events and celebrations took place. I recall Donna being warm and welcoming. As I got to know her more, there was no doubt in my mind that she was a loving and devoted wife, mother, and grandmother. Roman's birth was a scheduled cesarean section on December the 5th. On that day, I was overcome with mixed emotions of excitement and fear. A family awaited Roman's birth at the hospital during unnerving procedure. Donna was affectionate and compassionate, as I was visibly anxious and emotional. I will always remember how she reassured and calmed me that day. We shared tears of joy and the hugs when a beautiful and healthy boy came into this world. Donna was caring and supportive of Bree as a new mom. I have many fond memories of time spent with the Adelsons. Although Charlie and Bree were no longer a couple beyond Roman's first year, we all remain close. Donna has been kind, thoughtful, loving, and generous. Thank you sincerely for taking the time to read the letter, Jessica Goosery. And then a short letter to whom it may concern. I've worked at Adelson Institute for Aesthetic and Implant Dentistry from October 3rd, 2011 to September of 2022. During my time of working there, I had the opportunity to experience the beautiful person that Donna Adelson is. Through my time of working often side by side with her, I've witnessed her grace and ability to diffuse upset patients. She is incredible with having compassion for others and is truly one of the sweetest people I know. She's so supportive and understanding when it comes to her employees. When an elderly person comes in as a patient, she always made sure they had assistance, whether needing help filling out forms or even opening the reception door for them. She always jumped at the opportunity to be kind and helpful. I witnessed this and I know it was sincere. I still use what I've learned from her and apply it while I'm at work every day. I recognize the gravity of the situation and understand the seriousness of the legal process, but I respectfully ask that you consider the positive qualities that define her. Sincerely, Erica Johnson. And then the last letter that we submitted from was Attorney Gary Cohn. He said, my name is Gary Cohen. I've been a member in good standing at the Florida Bar since 1980. I have known Donna and Harvey Adelson as personal friends and personal counsel for almost 40 years. Harvey was also my dentist for most of those years. I have been in the Adelson house, and they have been in mine numerous times over the years since their children were little ones. My wife and I have socialized with Harvey and Donna at dinners, blessed events such as bar and bat mitzvahs, and weddings, birthdays, and many other occasions. I've also traveled with them, including a wonderful trip to Africa with two of my sons several years ago. I therefore have had a unique opportunity to observe Donna under many circumstances. In all the time I have known her, I have literally never heard Donna raise her voice, lose her temper, act inappropriately, or treat anyone with less than full respect, and almost always with a smile on her face. I have never heard a bad word said about Donna from any other friend or person in my presence. She has always been an amazing mother to her children, and she and Harvey have had the most loving marriage that can be imagined. While I cannot comment on any of the facts of this case or any of the alleged events, I can say that the Donna I know is the last person I would ever think of when it comes to what has been this utterly horrible crime dealing with the death of Dan Markel. Being a trial lawyer for 45 years, I fully believe in the jury system and understand that a jury has spoken. However, the woman I've known so well for so long also needs to be understood as the wonderful wife, mother, grandmother, and friend that she has been known to me. I only hope that this information can be of use to the court when it comes to the sentencing of Donna Adelson. Gary Cohen. At this time, I believe that Mrs. Adelson's husband, Harvey Adelson, would like to address the court.
Very well. Do you wish to enter these letters into evidence?
Yes, Judge.
Does the state have any objections?
No, Your Honor.
They will be composite defense 1 for sentencing.
Thank you, Judge.
Dr. Adelson, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, I do.
You can lower your hand. You may speak.
Thank you, Judge, and respected officers of the court for allowing me to speak. I have been Donna Adelson's husband for over 50 years. My wife sacrificed everything so that she could pour her heart and soul into our children, our grandchildren, and our marriage. This summer was our 54th wedding anniversary, and I had to spend it without her, hand in mind. She has done nothing wrong, and yet is being punished for a crime that she did not commit. I thought we lived in a different kind of world, but I guess I was wrong. I have listened, watched, and sat in the courtroom for the entire trial, and I could not help but scream in my mind by the witnesses that were brought forward by the prosecution who told outright lies. I didn't know that you could lie in a courtroom, but apparently you can. Danny's parents contend that they have never seen their grandchild. But for years they say they've never seen her. But Wendi has shared with me pictures and videos and letters from their visits. They have suffered immensely at the loss of their son, but they also contend to tell lies to the court about our grandchildren. Donna has always been a loving and caring wife and is innocent of the charges. A biased judge and jury were influenced by years of one-sided news pieces and
Before you
social
continue,
media.
Doctor, Ms. Fulford, this has nothing to do with the character of the defendant or at least the sentencing.
May I just a moment, please?
Go ahead.
Thank you.
You knew Judge Everett wasn't going to take that crap as soon as he started indicting the judge, a biased judge and a biased jury. Dude, this is not your soapbox here. You're supposed to be trying to help your wife, who you can't help. I mean, when he says, I've been married to her for more than 50 years, how many people said, oh, poor bastard? Come on. You did. And so he thinks that his anger at the process and the result and is the fault of everybody but Donna Adelson somehow helps her, even though it will have zero impact on the actual sentence. Zero. At least you have to assume that that's your goal, right? And he's totally lost it here, and the judge is not going to have that crap. He's got nothing left to say, probably, after the editing with Jackie Fulford. See, in those 40 phone calls, Jackie, that you had with Donna Adelson, you might have touched on this. You might have mentioned you want to cool Harvey down. He may be pissed, but that's not this job right here. That's not what he's there for. Remember, just look at this in a vacuum. Let's say there's really going to be an impact on the sentence. Is your goal to piss off the judge? No. If anything, he should be saying, the even-handedness of the court in this matter.
Thank you for letting me continue. Donna did not participate in the heinous acts that she was convicted of doing. You are sending an innocent woman to prison. You have taken my wife and you have taken my life as well. And for what? This is not justice. It is vengeance, and it is wrong.
You have an examination for Dr. Adelson.
No, Your Honor.
No, Judge.
I knew there wouldn't be much
Witness
left.
Statements that you wish to give.
I don't believe so, just one second.
Yeah, Madera Beach caregiver, thank you again. So generous. Yeah, he's, he may have plenty of time to stare down the judge, right? Going forward.
We don't have any further witnesses, Judge, but Mrs. Adelson has decided she would like to make an unsworn statement to the court.
Unsworn?
Yes, Judge.
All of the witnesses will be sworn this afternoon if she wishes to speak.
Judge, the case law indicates, confirms that the defendant has the right to make an unsworn statement prior to sentencing. The court, Rule 3.720B states the court shall entertain submissions of evidence by the parties that are relevant to the sentence. A number of cases, Your Honor, that have interpreted this, especially in a capital case, as the defendant having a right to make an unsworn statement. This is a capital case.
Please give the citations.
Yes, Your Honor. Excuse me. First is Smith v. State, 268 Southern 3rd, 831. It's from the first DCA in 2019. You want me to continue, Your Honor?
Give me one moment.
Yes, sir.
Bringing up my Westlaw.
I give him credit for being prepared. They got
Give the citation again.
Sure. It's 268 Southern 3rd, 831.
Clearly that answers the question, will she make a statement? She still may not, if he won't allow it unsworn, but she cannot help herself. She wants to set the record straight. This has been just a major injustice, and poor Donna is suffering at the hands of the biased court and jury. Yeah, a lot of folks are wondering why unsworn. Well, you know, you come back to bite her in the ass on appeal and any other motions that are brought. I can't believe she's going to say anything of substance. It's all going to be poor me, poor me. I didn't do this.
Which pinpoint site are you referring to in the case?
Let's see.
Oasis Cat suggests she's going to take this time to rat out Wendy. That'd be something.
So, Your Honor, I'm going to give you this one. It's Hill versus State, 246, Southern 3rd, 392. It's from the 4th District Court of Appeal.
One moment.
Yes, sir.
246, Southern 3rd, what's the last part?
392.
You know the judge is checking this stuff out. He may even take a break to check it out. You notice she either she had an earwax cleaning or it's a miracle, but she can hear today. No headphones.
Well, seeing in the case where it does state the defendant has a right to make an unsworn statement, we will proceed.
Thank you, Your Honor.
Okay. I give him the credit.
Mrs. Adelson at the lectern or here?
She can remain at council table.
Thank you. I'm going to move the microphone.
Oh, here we go.
And then you speak loudly because this is not amplified.
Okay. Is this loud enough, Judge?
I can hear you.
Thank you for letting me speak. My son-in-law, Dan Markel, was a fine and decent man. He was well educated and passionate about his career. He was a good son-in-law, but more importantly, he was a caring and loving father. On July 18th, 2014, his car was followed, leaving his home. It should have been just like any other day, an ordinary day in the life of Ben and Lincoln's father, but it wasn't. He didn't know when he left his boys off at daycare that would be the last time he would see them, and the last time they would see him. He didn't know when he went to the gym afterwards that would be the last time he would exercise. And he didn't know when he drove home that his life would end within minutes. Danny wasn't just being followed, he was being hunted. He was brutally murdered in broad daylight, sitting in his car, in his garage, by vicious killers. I cannot imagine the terror he felt when he saw a gun pointed at him through the window of his car. I cannot conceive of his heroic efforts to stay alive during the hours after the attack. Danny died in the early morning hours of July 19th. His death is a loss to his children, his parents, his sister, all of us in his family, his friends, his colleagues in the legal community, and to his students at FSU Law School. Danny's boys each have a photo of themselves with their Abba, their dad, beside their beds. They grew up kissing the framed photo and saying, "Good night, Abba, I love you." The pictures and memories are all they have because cruel, cold-hearted people took him from all of us who loved him. My heart was broken when Danny died. My grandsons were going to grow up without the father who loved them. I wondered, how could we help these boys through this trauma? It was then that my husband and I knew that the best way to honor Danny's memory would be to share with these children an abundance of love, the love that Danny would have given them if he were alive. It is interesting how the state can't make up its mind about who is what they call the, quote, mastermind behind this murder. In both of Catherine Magbanaw's trials, the state claimed she was the mastermind behind Danny's murder. In my son Charlie Adelson's trial, they claimed he was the mastermind. And now in my trial, they claimed that I, this grandma, was the mastermind behind the murder. I had no idea that other people planned to cut Danny's life short. And the people who did this are exactly where they deserve to be. But I had no knowledge that this horrible, evil act was going to take place. If I had become aware of this plan before Danny was murdered, I would have stopped it. With not one iota of actual evidence, the state convinced a Tallahassee jury that I solicited and conspired with other people to have Danny killed. Where is the evidence prior to the murder? The evidence beyond a reasonable doubt that the state needed to prove their case. Where is the evidence before July 18th, 2014 at 10:50 in the morning?
Before you continue, Mrs. Adelson, as it relates to this statement, is the defense trying to re-argue the trial?
No, Judge, just giving Mrs. Adelson an opportunity to be heard.
Mrs. Adelson, you certainly can continue. However, the court can take into consideration the utter lack of remorse that you are displaying. Please proceed if you desire to do so.
Where is the evidence before July 18th, 2014 at 10:50 a.m. that revealed that I had any involvement in this vile and horrific act? Where is the solicitation and conspiracy evidence? The state needed to show that there was evidence before the murder to convict me. The state couldn't show that because there wasn't any evidence. They were trying an innocent person. It makes you wonder if the jurors were sleeping when the state had Sergeant Corbett on the stand for hours. Their own star witness testified that my phone was never, I repeat, never at my son's house on the night of the murder. The state's theory that my husband and I dropped off money to my son was blown out of the water by their own witness. And yet, the state continued to push that story, that lie of the so-called money drop to the jury through the remainder of the trial. And the jury bought into it, hook, line, and sinker. Reasonable doubt. Many months ago, my attorneys filed a motion for a change of venue. An expert witness testified that Tallahassee had been barraged with over 9 years of negative social media, printed news, television news, and podcast publicity about my family. He explained to the court, both with evidence and demonstratives, that for me to receive a fair trial, it needed to be held in any of the researched and designated areas in the state of Florida other than Tallahassee. All I wanted was a level playing field, but the court wanted the trial here in the hotbed of Tallahassee. I sat through 3 days of jury selection. 180 potential jurors were asked if they had developed an opinion in my case. Those that answered yes also added, "I believe she is guilty." not one person, not one, said, I think she may be innocent. That should have been a clue to the court to grant our motion for a change of venue, but the court denied the motion. One of my jurors admitted during jury selection that she had background information concerning what one of the state's witnesses would be testifying about. Why was she allowed to be on my jury?
What moment?
Another juror.
Mrs. Fulford,
Oh, I didn't hear you.
Mr. Zellman, again, this has nothing to do with elocution of any sort. This is a raising of grievances, which are properly given to the appellate court. What does any of this have to do with sentencing?
Brad, just one moment, please.
Doing some editing once again. I think the judge is saying, can I give her life without parole twice? Can I increase this? He tried to warn her. You know, this could go against you, and that relates to the two charges of conspiracy and solicitation. Those have some parameters the judge can work within.
Turn that phone off or step out.
Uh-oh. I know the bailiff who's on that right now. She was a tough cell phone police person. But he was trying to warn her, you know, you're not helping yourself here. But, you know, I hope you've enjoyed the closing argument. That might be better than the closing argument the defense gave. I'm not sure. But that's just not what you're here for. But as we knew from the beginning, she cannot shut up. She wanted to testify. She was talked out of it. She regretted it when the verdict came down. And now this is, you know, in her mind, at least something. Oh, it's something, all righty. He probably just scratched out the 30 years that the state has asked for the other two charges and wrote in 50. She was like, there's nothing left. There's nothing left here after Jackie Fulford does her editing. So at a certain point, the attorneys have some responsibility. You know, it should have been prior, not during, but you know, they know what this process is about. And it's not, you know, the judge has said two things that are key here to what he wanted to hear. Allocution, meaning what really happened, and remorse. There's not a shred of remorse. The only thing the court cares about, again, if it mattered on the ancillary charges, it doesn't matter on the top charge. He's done. Life without parole. But the only thing they care about is seeing some sort of remorse from the defendant that's been convicted.
Please.
What happened to Danny is unforgivable. But I am an innocent woman convicted of this terrible crime without evidence. Danny was a brilliant legal scholar. He would have been appalled at the total lack of justice that went on during my trial. He would have been embarrassed to have his name associated with any of it. There are two crimes here. The first was Danny being viciously murdered. The second one is taking my life, the life of an innocent woman. Convicting me should not be retribution for Danny's death. That is not justice for Dan. I've always respected the law. I've never gotten a parking ticket, but I'm going to prison for a murder I did not commit. I do intend to file an appeal so that hopefully I have the opportunity to be given a fair trial outside of Tallahassee. 11 years ago, Danny was murdered and taken from all of us who loved him. For the past 9.5 years, the state has broadcast to the world, including Danny's parents and sister, that I hired hitmen to kill him. Never in a million years would I have wanted Danny to be harmed or killed, nor could I ever do something that would leave these two small boys to grow up without him. I love these boys more than life itself. This is a lifetime of loss for these children. They didn't deserve this. His family didn't deserve this. Danny didn't deserve this. And so, as I appear before you today, Your Honor, I promise you with my whole heart, I swear to you on my life, I was not involved in any way with Danny's murder. I was not.
And scene.
Defense have any further argument to make?
Yes, Judge.
Judge, before Ms. Fulford makes the argument, I want to address a comment that the court made a few moments ago concerning considering lack of remorse in fashioning a sentence. In Shepherd v. State 227 Southern 3rd, 746, the First District Court of Appeal held that lack of remorse cannot be considered in fashioning an appropriate sentence. If this were a situation where remorse and admission of guilt may be grounds for mitigation, the lack of these factors cannot be used to increase the defendant's sentence, and such reliance violates the defendant's due process rights. And they also rely on Ritter v. State 885 Southern 2nd 413, also a first DCA case.
I believe the Supreme Court has ruled on this issue concerning remorse and lack of showing remorse as well. If you need me to find the citation for you, I will.
Yes, please.
We'll take a 10-minute break.
All right, now the judge has to go round up his law clerk because they're arguing. Basically, Mr. Zellman, he's arguing that, Judge, it's okay if the statement includes things other than remorse.
We'll resume at 4:16.
So he didn't have the cites at his fingertips, but the judge says there's Supreme Court law on this. So whatever case law you have from the area, from the region, it's not controlling on me. It's probably not even persuasive, and those are the two levels of legal authority. If it's in your jurisdiction and the facts are pretty similar, in this case, it's straightforward. It's pre-sentencing statements by the defendant. Then it would be controlling on the court. But if it's from a different jurisdiction or it's a scenario that is totally different, then maybe it's persuasive, but certainly not controlling. And the judge is saying, I got the Supreme Court to rely upon here. I will give credit to Zellman on the first argument that he made and won, which was that the statement can be made without having the defendant sworn in. Because a judge, if nothing about Judge Everett, when he tells you something, he damn well believes it. Okay, he's not waffling. In his mind, it is the God's honest truth, and that's what I'm going to impose. But when it was pointed out to him, and two cases were cited, one in the First District Court of Appeal, one in the Fourth, that no, in fact, it is okay to have the defendant make a statement unsworn, and he backed down. He said, "Okay, let's go." But then, then the fun began. I think I'm going to have to give her my Emmy because it was impassioned. I mean, let's just talk about some of the details. I mean, my overall impression is, here's this woman who's now been convicted in the death of her son-in-law, Dan Markel, and her statement prior to sentencing takes a big shit right on his grave. Like, as if she was somehow a drive-by. Just hearing about it and just deciding, I'm going to be as outraged as anyone because this should never have happened. I'm hearing that I'm blurry. I'm blurry? Oh, let me see if I can do this. That might help my blurriness, but I look like I have strong signal here. Looks like I have the signal that doesn't get no better. So hopefully whatever the blurriness is usually I speak in blur, but usually I'm not blurry. Any better? It's still blurry? Very curious. Well, let's let it go for a moment and see what might come of it. The weather is pretty bad, but it's not that bad. Sometimes, let me look at the source. No, it looks like I've still got hardline signal. Curious. No idea whether, Okay, it's the camera. Well, is it? Is it really the camera? There's not exactly a fancy thing. Tell me, anybody look better? It looks like Vaseline on the screen. Well, I do that. It actually reduces my age quite a bit. I call it the Elizabeth Taylor effect. Sometimes we'll shoot through cheesecloth. Anyway, hopefully it's cleared up. I don't know. Everybody says I'm blurry. How about the audio? Is the audio good? I'm just going to continue on because I think there's nothing technologically weird about what's going on, whether it's a weather factor or not. Could be weather. Okay, so let's talk about the statement. Let's get into the statement beyond my overall impression of it. You know, she gets so mad. She's talking about how he was hunted. I mean, that is just so disrespectful to the family. If you're not going to say anything that sounds like contrition, then shut the hell up. But she couldn't. She couldn't. She talked about she was making, as I kind of kidded that she was making a closing argument. But if you tear into some of her statements, she focused on what there was and wasn't available in terms of evidence about prior to the murder versus after the murder, right? That's the argument you make if you're suggesting that anything I did wrong was an accessory after the fact, for which she was not charged, right? So it's an interesting part of her statement to make when, I mean, it's too late now. The horse has left the barn, whatever analogy you want. But in her mind, she's throwing the court a bone. Like, hey, judge, if I did anything, it was after the fact. I just think that's a very bizarre position to take at this point. And we talked about it all during the trial. Every little bit of evidence that came in, does that implicate her post-murder or pre-murder? It was obviously every charge, murder, conspiracy, solicitation, all relate to setting it up and having it carried out on your behalf. None of the charges had to do with covering it up. Now, covering something up can give you guilt of consciousness for the charges that were actually levied against her, but there were no independent charges for covering up. There was no any sort of obstruction or spoliation of evidence. None of those things, which would be typical if you were the target of an after the event crime, and she wasn't. Let's see. And again, I'm flabbergasted that she could be warned. First of all, that she would go into this, her attorneys left her twisting. They did not do their job on this front. May have done their job about whether she could make an unsworn statement or not, but they should have told her the tone of this, the detail you're going into, are inappropriate. Now, maybe they did, and she just said, "I don't care. I'm going to say what I want to say." Wouldn't surprise me. But it puts the attorneys in a horrible position. And then whatever fear they may have had that what she was putting out there was going to be a problem is confirmed when the judge says, "Whoa, hold on a second. What does this have to do? We're not retrying the case here, Ms. Adelson. I've heard nothing about remorse. And this tone, I mean, it's just like Harvey's. We'll talk about Harvey in a second. But Harvey was the same way and got called on the carpet for the same reason. Don't stand up here, sit in her case, and say the judge is biased. And if I've gotten a change of venue, which is where Harvey didn't go there, he just said the court was biased, the jury was biased. But Ms. Adelson said, well, we wanted a change of venue, and look at, see, told you. She's even going into how many jurors were in the courtroom. She took obviously very good notes. Of the 183, how many said that they had heard about the case and then said, I think she was guilty? I mean, that is some delirious hard work to try and pull yourself out of the hole that she's in. And obviously it's not going to work. And she just didn't care. I'm not sure what Jackie Fulford was able to carve from her statement. But because there was still some left, and she went right back to that same tone of, I've been screwed, it's the court's fault, I didn't do nothing wrong. And then, she said, I love those boys more than life itself. That's one of the last things she said. My first thought was, yeah, and that's why you had Dan Markel killed, because you love them more than life itself, and you love them certainly more than his life. Because doing that to him allowed you to have those boys that you were so in love with more than life itself. So I don't know if she's thinking this process through when she's considering the impact of what she says, because that statement to me alone confirms her motivation to get rid of Dan Markel. And somebody said, I saw it, was that Harvey's phone that rang? Is there any way we can confirm that? That would be obviously poetic justice and ironic. But I don't have that confirmed. That may have been somebody just having some fun. So anyway, so let's talk about Harvey for just a second, because he was pissed off. And again, if you're in his position and you've been through all of this as he has been, even if you assume he has some level of culpability, and we just don't know yet, I think he has some, hasn't been proven yet, he's still going to be pissed off. He's still going to be mad at what has happened to his family, culminating with his wife of 50 plus years, which still makes me shudder. He was angry. And I just don't know what's going through his head. Is it, oh, this will help my wife? Or is he just saying, the hell with it? I don't care. I know there's nothing I can say or do that will help her. So I'm just going to get this off my chest, The other Karen, Michael, can you blame her? She's pushing 80 with no hope. No, I mean, she's desperate. We've seen that many times. And thank you, other Karen. Yeah, she's clearly desperate. And maybe in her mind, just being able to vent it has some value to her. This is not a woman that likes being ignored. And for the course of her trial, she was ignored. I mean, she was bad-mouthed, and people talked about her and blamed her for many things. The jury had the ultimate criticism of her actions, and they found her guilty. But she never got the chance to chime in. And this is not a woman that sits around and just nods when other people are talking. She's in. She's all in. And today was the first chance, because she didn't testify, first chance that she had to talk about the case, about the evidence, about the jury, about the law, about the son-in-law she lost and had nothing to do with, and of course about those grandkids that she loves more than life itself. Well, let's see how the research has gone on this.
Review Davis.
Briefly, Your Honor, Davis was not a capital case. This is a capital case. Although the criminal punishment code would only apply to the non-capital cases, I would already submit to Your Honor that it is distinguishable under those circumstances.
Going to read from Head Note 8 and 9. Nor was Davis forced to choose between allocution and maintenance of his innocence. He certainly could have allocuted without voicing his disagreement with the verdict, blaming the driver, the police, his lawyer, the trial court for his conviction, and attempting to explain his personal interpretations of the law to the judge. He could have asked for leniency without admitting guilt. He could have provided the judge with reasons to impose a sentence less than the maximum besides his claimed innocence. But he instead chose to make a lengthy statement claiming innocence, denying responsibility, and placing blame for his conviction on the alleged misconduct of others. The trial court was under no obligation to ignore such statements and did not err in considering those statements and imposing the legal sentence here. Do you have anything that distinguishes Davis in any way?
As I said, Your Honor, Davis was not a capital case.
Very well. Any other argument or evidence the defense wishes to present?
Yes, Judge, thank you.
Please move forward.
Your Honor, we're aware that in count one, the court has no choice but to sentence Mrs. Adelson to life for the first-degree murder charge. We are going to request a downward departure as to counts 2 and counts 3, the solicitation and the conspiracy counts.
What are the grounds?
Pardon me?
What are the grounds?
Yes. The grounds are, one is non-statutory, and that's disparity in the treatment between co-defendants. And the second reason is statutory, and it is Florida Statute 921.00262B. The defendant was an accomplice to the offense and was a relatively minor participant in the criminal conduct.
The evidence in support of sub B would be the trial record, or do you have something more specific?
For 4B, we're going to rely on the trial record with respect to the conduct of Mrs. Adelson, and we would ask the court to take judicial notice. Your Honor did preside over Charlie Adelson's trial, and the evidence regarding the other co-defendants' activities or participation was also brought out in the testimony in the trial of Mrs. Adelson, so we'd rely on that record, Judge.
Ms. Kappelman, as to the argued grounds for statutory mitigation and also non-statutory mitigation, does the state have any argument to make?
No, Your Honor.
You may continue.
Thank you, Judge. I'll start with the disparity. Do you need case law citations for this, or you're aware of it, Judge? Okay. The first case would be Sanders v. State, 510 Southern 2nd, 296. This is a Florida Supreme Court case from 1987.
One moment. 510 Southern 2nd. What was the other part of the citation?
I have copies, Your Honor.
296, and that's Florida Supreme Court in 1987.
Go ahead.
State versus Fernandez, 927 Southern 2nd, 939, which is a third DCA case from 2006.
May I approach, Your Honor?
You may.
And then the third case, Judge, is State, I can't pronounce it, but State versus Kunkemoller, 333 Southern 3rd, 335. That's a first DCA case from 2022, but it is distinguishable because it does not address the issue of culpability as the first two cases do, but I wanted to bring that to your attention.
Just like the entire trial, there had to be these little, moments where everybody was getting their shit together or not. This is all just academic, you realize. It's not going to change whatever years she has left in her life. Behind bars, period. Of course, there's the wild possibility of an appeal that might change that, but I would not bet on that. I think LKB would say that's like drawing to an inside straight, at best. I know a lot of folks are mad. They're like, just go, let's do it. We want to hear the magic words, life without the possibility of parole. But this is the process, dragged on as it is by some interesting lawyering. Did you hear when you see Harvey there and see his friend next to him? That's Richard Chagrin. He pronounced it Chagrin. The court said chagrin, which is how it's spelled. You can't help it. But nobody wants to be chagrined as the last name. And now that Donna's had her day, she must be thinking, I nailed it. I nailed it! He's only going to give me one life sentence now. Whew. Harvey, somebody, let's see who says that. Oh, Sheila Duffy. Harvey looks so angry. He's angry because he has now a lifetime of 5 hours a day talking to this woman from prison. That's Harvey's life. And I just say that based on the records. I don't know. Maybe that'll change. Maybe he'll have his own limitations. I believe we are getting to that moment. We have to. And am I still blurry? I checked the camera. Camera is fine. Microphone, fine. I'm getting the court feed, fine. So whatever may have been causing it, I don't know. Or is still causing it, I do not know. I apologize on behalf of Geek. Is there a Geek Squad? Can I arrange a Geek Squad to come here? Oh, and then when they were reciting all the information about the pre-sentencing report, all the corrections that had to be made, including, well, she's never had a job, basically. She's on Social Security. Well, just this little chunk of calls, 119 of them answered. That was $380. So that will eat up your Social Security very quickly. Apparently she's been distanced from the family wealth for purposes of making it look like.
Thank you, Judge.
Help me. I got
I'll start
nothing.
with the disparity argument, if I may, Your Honor. In this case, there have been several co-defendants who have either been tried or entered pleas and received sentences. I want to, for this particular argument, relate exclusively to Luis Rivera. He testified in the trial, and through himself and other witnesses, Your Honor has heard what he did in this case. And what he did in this case compared to what the state has alleged and the jury found that Mrs. Adelson did, the culpability levels are very different. Mr. Rivera was allowed to enter a plea to second-degree murder. And although, as the PSI indicates, he received a sentence of 19 years in the Department of Corrections, that was run concurrent with a sentence he was already serving in a completely unrelated matter in a federal case where he got a 12-year sentence. So the number of years that he will actually serve for his participation in the homicide of Dan Markel is 7 years in the state of Florida Department of Corrections. His conduct, as Your Honor can recall, is that he traveled to Tallahassee sometime in June and scoped out the home of Danny Markel, engaged in some drug activity with Sigfredo Garcia, and then returned to South Florida. A few weeks later, he returned to Tallahassee and again scoped out Danny Markel's house. But he didn't just do that. Prior to arriving in Tallahassee, with himself knowing that he and Sigfredo Garcia were going to kill Danny Markel, he purchased and provided the very firearm that was used to kill Danny. He came to Tallahassee and they sat in wait outside his home. They followed him with Mr. Rivera being the driver, followed him while he took his two little boys to daycare, and he sat and watched as Mr. Markel, hand in hand, took those children inside the daycare. He then followed Mr. Markel all the way to the gym, sitting in wait. What was he waiting for? He knew what he was waiting for. Mr. Markel did not. He had no clue that these men were outside in a car just waiting for him to go to a place where they could shoot and kill him. And they waited until he exercised. They watched him get back into his vehicle, and then, like hunters, traveled and followed all of this time period straight to his home. And there was no hesitation. He knew exactly what they were going to do. Without any hesitation, they pulled right in behind Danny. Danny's car was still running, the garage door was up, and Sigfredo Garcia exits the car and shoots Danny Markel, having done nothing to these men, in the head twice. How Mr. Markel survived, I don't know. But then Luis Rivera is the getaway driver. They flee the scene, they flee Tallahassee, and then Mr. Rivera stops to allow Sigfredo Garcia to dispose of the murder weapon, which has never been found. And then he drives back to South Florida like nothing has happened, purchasing motorcycles and cars, but most importantly, getting paid for the work that he's just done. The payment came from Catherine May Banois, and I'll address her in the next segment. The point here is, Judge, that over time, reading different things, you've heard a lot of arguments about what Mrs. Adelson's participation allegedly was. But when it comes down to it, and I didn't mention, but Luis Rivera did have an extensive criminal history at the time that he committed this offense. What actually came out at trial with respect to Mrs. Adelson, and I'm saying this, understanding, as you've learned, that Mrs. Adelson still maintains that she is innocent of this conduct. But what the state was able to show through their testimony and evidence was that the role that she played, according to them in the prosecution, was very minimal. The evidence showed that she was very upset when relocation was denied in 2013, not knowing that her daughter had agreed to it, not knowing that until she sat here in trial hearing her daughter's testimony. She wrote some very ugly emails. She said some very ugly things. But in not one of those emails did it ever say that she wished harm upon Danny Markel. And this was in 2013. The evidence was presented by the state that was over a year later that Danny was killed after relocation had been denied. Although they argued that there was continued hostility on the part of Mrs. Adelson regarding the issue of relocation, with the hundreds of thousands of emails they had, they didn't present evidence that this ongoing dispute was being brought up in any way between the parties. The relocation between them, that issue had stopped. The testimony that was elicited was that Charlie Adelson, the son of Mrs. Adelson, was the one who was close with Mrs. Adelson, and that when she had a problem, the argument from the state was, when she had a problem, Charlie was the problem solver. And the testimony at court that was presented by the state supported that theory, that Charlie was the problem solver. They further elicited evidence, testimony, that without any knowledge of what the phone calls were, Catherine Magbanawala testified that when she was with Charlie Adelson discussing scenarios, which she didn't describe what scenarios she was discussing, that on occasion there would be a phone call between Charlie and his mother. She didn't hear the mother speaking. In fact, he left the room when he talked to, allegedly, the mother, and he came back in. He never relayed to her any information about the phone call. But the state's theory and the evidence that they presented was because Donna Adelson had been so upset about the fact that relocation was denied, and she continued to be upset, according to the testimony, that Charlie Adelson took it upon himself to reach out to someone, which was his girlfriend, and have her get someone that she knew who could commit this murder, make contact with them. According to the testimony in the state, in this case, Charlie Adelson told Catherine Magbanawala, I'm not trying to be disrespectful, it's just those are the names that were reused, but Mrs. Magbanawala, that she wanted him killed and he would pay for that to happen. Her testimony was she had no idea what the payment was going to be, but she did in fact reach out to the father of her children, Sigfredo Garcia, and he agreed to commit the homicide. Mr. Garcia then elicited Luis Rivera to participate with him in the homicide, and I'm not going to go through all the evidence in the case. I want to focus on what Mrs. Adelson allegedly did. Up until the point of the homicide, the only evidence that was presented about Mrs. Adelson's participation were those ugly emails. And there's a distinction, as we discussed during the trial and sometimes even at sidebar, of the evidence being up to the moment that Mr. Markel was killed. Up to that time, the only evidence introduced by the state in this trial for that time period were those ugly emails, and they were ugly. She called him very foul names. She said some ugly language. She clearly was not happy. And whatever conversations may have taken place while Catherine Magbanawala was inside Charlie Adelson's home and Charlie was outside talking to another person. Mrs. Adelson maintains her innocence. But if you're looking at this particular cause of this disparity in treatment, the state is asking that Mrs. Adelson be sentenced to, obviously, life on count 1 as she has to be, followed by 30 years in the Department of Corrections on counts 2 and 3. This is far in excess of the sentence that was received by the man who himself testified to hunting down Danny Markel, providing the gun for him to be murdered with, leaving the scene of the crime, disposing of the murder weapon, and going on with his life and his gang as he always had. In that disparity, Judge, it just doesn't reconcile with the facts here of what they say Mrs. Adelson did. Although there was a theme that she was the mastermind, I would argue to the court that the evidence did not show she was the mastermind in any way. The masterminds that were shown in this trial were Charles Adelson and Catherine Magbanawah. It didn't show any activity prior to Mr. Markel being killed where Mrs. Adelson was involved in any way.
Take away what you're arguing as the theme for the moment. The chief difference between Luis Rivera and your client is he entered into a plea, correct?
That's correct. He did enter into a plea, but that, according to the case law, that can be considered.
And he has also cooperated with the state, testifying in many trials.
He was a cooperating witness testifying in these trials. Mrs. Adelson not only has maintained her innocence, she was never offered anything from the state.
Please continue.
On the statutory basis that the defendant was an accomplice to the offense and a relatively minor participant in the criminal conduct, some of what I've just argued applies to this one as well, Your Honor. But what I wanted to point out here were the ones that we didn't discuss. So Sigfredo Garcia was found guilty at trial, first-degree murder and conspiracy. His sentence was life on the homicide and an additional 30 years consecutive for the conspiracy count. He is the one who rode in the car. He is the one who obtained Luis Garcia to go with him. He is the one who sat in the seat knowing he was going to exit the car while they hunted down Danny Markel. And he's the one who got out and shot Danny Markel in cold blood. Left like nothing had ever happened. Along the way, made many stops, including getting out to hide the murder weapon, and then went on with his life. The killer is getting the same sentence that the lesser participant, the state is suggesting, get as well. Life in prison on count 1, followed by 30 years for the conspiracy and solicitation. Luis Rivera, I've already told you what his role was. Catherine Magbanawah got the information from Charlie Adelson according to the evidence, and at his request obtained someone, Sigfredo Garcia, to do the killing. She is the one who coordinated between Charlie Adelson and Sigfredo Garcia and Luis Rivera. Although she testified that she didn't know Luis Rivera was involved until after it was over, the evidence that the state submitted clearly contradicts that. She was communicating with Luis Rivera before, closely to the homicide, and then shortly thereafter. She's the one that spoke to him. She was sentenced on the first-degree murder to life in prison, and on the solicitation and conspiracy, she was sentenced to an additional 30 years. It was run consecutive. Again, the same sentence that they're asking for on Mrs. Adelson is the sentence that this woman who heard the request for a homicide, found the person to commit the homicide, stayed in communication with both of the individuals who are responsible for killing Danny Markel, followed up with them and provided payment to them, and then took payment back from them for her to keep for herself. She was also paid in this. She participated, knew it was happening. They had proof that she knew it was happening. That was submitted to the court. All of that evidence clearly distinguishable from the conduct that they presented in evidence about what Donna Adelson did. Charlie Adelson, according to the testimony in this trial and his own, Charlie Adelson wanted Danny Markel dead. So on his close or very first date with Catherine Magbanawah, he asks her out in public at Halloween, some Halloween function, hey, do you know anybody who could get somebody killed? According to her testimony, she followed through with that. With Charlie Adelson, never with Donna Adelson, never communicated with her in any way about this. She worked then, if that's what happened and that's what's been testified to, she worked with Charlie Adelson from October of 2013 until Danny Markel was brutally killed in July of 2014. That entire period, and there's evidence, she admitted to most of it, to her conduct, and there's evidence that was presented in this trial and Charlie's that that's what happened. They made this plan, and that his stapled money was used to pay the killers in this case some $130,000 in cash that It was divided up amongst Sigfredo Garcia. Sorry, my mouth was getting dry. Excuse me.
Go ahead.
Thank you, Judge. It was divided up between Sigfredo Garcia, Catherine Magbanawa, and Luis Rivera. She then stayed in contact with Charlie Adelson. She convinced Charlie Adelson to get paychecks written to her, and she received those paychecks each time from Charlie Adelson. So for what Catherine Magbanawa did and what Charlie Adelson did, the evidence in this case shows it went far beyond what the state's evidence showed that Donna did, up to and including the time that Danny was killed. So again, if you're going to rate the level of culpability in this case and consider Mrs. Adelson's conduct as compared to those, they're asking that she get the same sentence as both of the people who killed, well, one person that did the killing, Sigfredo, a far more extensive sentence than Luis Rivera, who participated in the killing himself and only got 7 years. The same as Catherine Magbanawa, that apparently worked on this according to the evidence for many, many months and stayed involved even after that. Charlie Adelson is the only one who got a higher sentence. His sentence was life on count 1, the homicide, followed by 30 years on count 2 and another 30 years on count 3, so everything being run consecutively. The evidence that the state has presented is that Charlie Adelson is the one who masterminded this. That's what they've shown. Even though they said Catherine Magbanawa wasn't her trial, if there's somebody who started this, according to the evidence, it's Charlie Adelson, not Donna Adelson. All the work being done was Charlie Adelson. All the money that was paid was Charlie Adelson's money. Mrs. Adelson, according to the state's evidence, did not do any of that. Again, they had hundreds of thousands of dollars, or hundreds of thousands of emails. Never one in all of those emails that we all had to go through did Mrs. Adelson ever suggest any harm to Danny Markel in any way. I understand the verdict, and she has a right to take an appeal, and that's what she'll do. But the evidence in what was argued is very far different in theory than what was actually presented to this jury. And I'm requesting that Your Honor, in determining a sentence on counts 2 and 3, take into consideration that the amount of activity that everyone engaged in this case was far, far beyond what was alleged against Mrs. Adelson. They just didn't come up with the proof for that. They did prove to a jury that she was involved, but that proof and the actual evidence was very limited to the conduct that they say that she engaged in that resulted in Mr. Markel's death. I do want to remark, if I may, just briefly on the issue of remorse. Mrs. Adelson maintains her innocence, and as she has a lawful right to do, will seek an appeal. She may not get another trial. There may or may not be parts of the finding of the jury that is reversed, may not. They can do that on, the appellate court can do that on 1, 2, or 3 counts. There are lots of options that the appellate court has. The reason I say that is this. Mrs. Adelson, maintaining her innocence, could not have shown more remorse for the killing of Danny Markel. And in her statement, although some of it I know was bothersome to the court, in her statement, I hope you heard.
I wouldn't say bothersome to the court.
Okay.
Please continue.
Okay. I misread then. I apologize based on your comments. One of the things she said in her statement, after most of her statement being about the horrible thing that happened to Danny Markel, was that the people who were responsible for it were in prison. That's a pretty big statement considering what the state believes Mrs. Adelson's position is with respect to the others who've been prosecuted, convicted, and are serving sentences in the Florida Department of Corrections. I also want to say this. The defense's position in this case, from start to finish, has always been on behalf of Mrs. Adelson, beyond respectful to the victim in this case, Danny Markel. He should not be lost in this case, and I said that in my opening statement. We presented evidence about a wonderful man he was. He did not deserve for this to happen. The Markels gave their statements at the conclusion of the verdict that was issued by the jury, and I listened to every single word. And every single word that they said came out of the terrible grief from the loss of their son and the feelings that they have developed over the course of this 11 years in prosecuting these various people and additional information that has been given to them. Every word they had every right to say. The feelings that they had are exactly what they should have. What happened to Danny Markel, as Donna Adelson has said in her statement, could not have been more horrific. He was treated like an animal, completely unaware that there was any kind of problem, that he would have any kind of physical altercation with anybody. I'm positive the furthest thing from his mind that day was that someone was going to kill him in his garage at his home. He did not deserve what he got. It's been very clear in the prior prosecutions and what was presented in Mrs. Adelson's trial about the conduct of these other individuals. They do deserve to be where they are. They do. Their conduct is unimaginable to me, that human beings would engage in that kind of conduct to bring a man, an innocent man, a well-respected man, an amazing father, to take him away from his mother, his father, his sister, most importantly, his children. That was horrific. I understand why those sentences were imposed. Not for Mr. Rivera, but for the ones that were tried and convicted. In this case, Judge, based on the evidence that was presented, the defense is going to ask on counts 2 and 3 that you sentence Mrs. Adelson to 3 years in the Florida Department of Corrections, counts 2 and 3 to run concurrently. My understanding in the court, the clerk can tell me if I'm wrong, but my understanding is Mrs. Adelson has 701 days credit time served. That's what we calculated.
I'll stipulate to 701, Your Honor.
Very well.
Anything more on counts 2 and 3, Judge? First of all, in order for it to assist Mrs. Adelson, she's going to have to be successful on count 1 on appeal. If she is, anything more than that period of time is going to basically be a death sentence for Mrs. Adelson. She is soon to be 76 years old. Her health has gotten worse while incarcerated, as anyone would probably expect. Her husband is 81 years old. Compared, 3 years compared to the man who participated in the killing getting 7 years, I believe is a just and reasonable sentence for Mrs. Adelson. We are also going to ask, Your Honor, after imposing sentence, I know it's nothing but a recommendation, but we would ask if you make a recommendation to the Florida Department of Corrections that Mrs. Adelson be placed as close to Miami as possible, where her husband resides, so that she can have visitation. I understand we don't have any control over Department of Corrections, but we would appreciate that recommendation. And may I have just one moment, please?
Go ahead.
While she's doing that, Judge, I would ask that Ms. Adelson not be housed with Ms. McBanow, or at least have a separation, if you could recommend that. I know Ms. McBanow is currently at Lowell, Seattle.
Yes, Judge, I thank you for that, Ms. Kappelman. I wanted to raise that issue because we did check into that. Judge, I contacted the Florida Department of Corrections. They did indicate that they would be able to keep them separate, but that doesn't necessarily mean that folks who are familiar with and friendly with Mrs. McBanow wouldn't be where Mrs. Adelson would be, so we are concerned about that, about her being placed at that facility. I didn't know it before, but the reception center for the women actually keep inmates there, so that I know that's a possibility, but again, that's in Ocala, and we're respectfully requesting that she be placed closer to Miami. Thank you.
Going to review the last case the defense has presented for downward departure. Ms. Kappelman, you had something else?
No, Your Honor, I don't.
Review the cases for downward departure, or in support of downward departure, the defense has argued.
I've heard from more than a few folks that it was Harvey's phone, so I'm coming and going. Apparently, it was a call from his travel agent confirming his one-way to Vietnam. Not confirmed. Easiest day in quite a while for Miss Kappelman. So there's been some talk that why are we going through all of this? Why is she talking about all these different, downward departure issues? It only relates to counts 2 and 3. And again, as we talked about right from the start, when we first opened up the Justice Served classroom here, there weirder things have happened. There could be a reversal on the top charge, bringing the second and third charge into play in terms of the ultimate sentence. So their job as a defense counsel for Donna Adelson is to do the best they can for her. That's their obligation. And if that's to attack these second and third charges to bring the 30 years recommended by the prosecution down at all, even if it's academic, even if the best case scenario, she gets a reversal on the top charge, and you know how long that could possibly take? I mean, I don't mean to be mean about it, but hard time is not normal time. She'll be doing hard time at age 76. I don't have the actuarial tables on that, but I bet you it ain't a lot of years, especially when you've come from a coddled life, a get everything I want life. She's been in jail now, not the big house, jail for a couple of years. I think it's safe to say if you look at the before pictures and the current pictures, it's taken a toll. And it ain't going to get easier when she goes to the big house. So my point is, best case scenario, if it ever becomes an issue where these secondary charges are lower years in jail, it'll be moot. I'm sorry, it is not going to matter. But from the attorney's perspective, that's their job. Their job is not to go, well, that Bryant guy said there's no hope, so what the hell are we doing wasting our time? No, they need to do this. That's what they're paid for. That's what they've taken an oath to do, and they're doing it to some degree of competence. I do think it's important, and it's interesting, the reference to Catherine Magloire, that they don't want, them housed together. I don't know how much pull Catherine Magloire might have to have something done to Donna Adelson. I don't know. Does it extend beyond this, if they were in the same prison? Because if it were a connected mob type thing, wouldn't matter which prison you were in. If somebody wanted to get to you, they would get to you. I'm not sure that's the case here with the Latin Kingette, or was she a Latin queen? I don't know. The friend of the Latin kings, Catherine Magloire, is she going to reach out no matter where Donna Adelson is? I don't know. But look at where Charlie is. He's in the Dakotas. So it's not like, oh, this is a state case, so it'll be somewhere in Florida. No, it could be anywhere. And certainly they have, fewer women's prisons than men's, but the number of possibilities they're not confined by geography. It could be anywhere. I think the judge is looking over the departure issues, right? That's what he's doing. I think I might have dozed off while he was making his transition. Yeah, and this is what we were just talking about here, Michelle 0317. She's got to go on and on about the things for which she has some argument, and that's what she's doing. But retrying the case is a bit much. I felt like at times, if you tuned in, I was like, oh my God, the appellate court's already reversed the case, and now we're into a retrial. It just kind of had that vibe. Oh, more importantly, where's Linda? Where is she? What's she doing? Where'd she go? She's on assignment. She had some stuff she had to take care of, so she'll be joining. I'm assuming this is going to be done by 6 o'clock because I got some prep still to do for that show, and it's now 5 till the top of the hour. So hopefully, this will wrap up pretty soon. I think it's a matter of if you've got the sentencing sheet, he's got to fill in a couple of blanks. Remember, the prosecution has asked for 30 years for each of the second and third charges, conspiracy and solicitation. I'm looking at my notes because one of them was going to be, the second was going to be concurrent with the first, meaning a total of 30 years, not 30 plus 30. And that all kicks in when? After life? Yeah, so it's a very ethereal kind of a concept here. But again, appeals happen, and appeals do change outcomes at times. Is this unheard of, all this filibustering? Michelle is very concerned about all of this filibustering. Again, you do what the court will let you get away with, and Judge Everett, he stomped on both Harvey and Donna Adelson to streamline what's going on. But as it relates to the downward departure arguments, he really, he doesn't have a lot of control over their making their arguments, unless he at some point just says, I understand your arguments, great. But that doesn't look good on appeal.
Having reviewed the cases presented by the defense concerning the downward departure, also as well the argument that has been presented, the court has reviewed its notes of the trial and will rule on the issue of downward departure at this point. Florida Supreme Court has a two-part test concerning whether a downward departure should be granted or could be granted by the trial court. The first is whether the trial court can impose a downward departure sentence based on a valid legal ground proven by a preponderance of the evidence. The second step is whether the trial court decides whether it should impose the downward departure based on the totality of the circumstances. As to both the non-statutory grounds that have been argued and the grounds contained within section 921.0026, subsection 2, subsection B, in reviewing the trial court's notes, what has been argued by both the defense and also as well the court's relying on the record itself, court will find that there is a ground for non-statutory downward departure, but it declines to exercise its discretion. As to the statutory ground, I will find that both the defendant was an accomplice to the offense and a relative minor participant in the criminal conduct. I will find that has not been proven, but in addition to, the court would still decline to exercise its discretion. As to the sentence in this matter, Ms. Adelson, please rise. Level of planning and coordination to bring the murder of Professor Markel to fruition was significant in this case. These were not crimes of chance or opportunity, and these crimes also required you to conspire with your son and others. You certainly can choose to deny your involvement and maintain innocence. The court finds the evidence in this case is clear. You will be sentenced accordingly this afternoon. The jury has found you guilty on charges of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder, and the court previously adjudicated you guilty as to these same charges on September 4th of this year. On count 1 of the indictment for first-degree murder, you are hereby sentenced to life imprisonment without the possibility of parole or release pursuant to sections 782.04 and 775.082 sub 1 sub A Florida statutes. On count 2 of the indictment, conspiracy to commit first-degree murder, you are hereby sentenced to 30 years in the Department of Corrections that will run consecutive to count 1. The court will also sentence you to 30 years in the Department of Corrections on count 3. Counts 2 and 3 are to run concurrent with each other, but consecutive to count 1. As to the fees and costs, the clerk can please announce those at this time.
$2,100 as a fine pursuant to section 775.083, $105 as the 5% surcharge required by section 938.04, $20 as a court cost pursuant to Section 938.06, Crime Stopping Trust Fund. $3 as a court cost pursuant to Section 938.01, subsection 1, Criminal Justice Trust Fund. $50 pursuant to Section 938.03, Crimes Compensation Trust Fund. $225 pursuant to Section 938.05, Local Government Criminal Justice Trust Fund. $2 as a court cost pursuant to Section 938.15, County Criminal Justice Education. $50 as a court cost pursuant to Section 775.083, subsection 2, County Crime Prevention. $65 as a court cost pursuant to Section 939.185, County Additional Court Costs. And $3 as a court cost pursuant to Section 938.19, Team Court Assessment.
Is there any lawful objection by the defense to these assessments? They will be assessed at this time. The cost of prosecution, the court will reserve jurisdiction on to determine for 60 days. If a hearing needs to take place concerning this matter, that will take place at a future time. As the defense's request for the court to make a recommendation to the Department of Corrections to place Mrs. Adelson in a facility near Miami-Dade County, I have no problem making this recommendation. The Department of Corrections will have the final say because this is an administrative matter. I will also recommend to the department that Mrs. Adelson is not to be placed in any unit or facility that would also house Catherine McBanawa. The court did previously award to the state, based on the September 17th, 2024 continuance of the trial, costs that were related to that. Ms. Kappelman, part of what you're seeking to pursue, is that included within that, or is that a separate number?
Are you speaking of the costs that were ordered in Charlie Adelson's trial?
No. The day Daniel Rashbaum withdrew from the case and the trial had to be continued.
Okay.
All costs related to moving witnesses and other matters.
Yes, sir. I don't know the answer to that, but I'll make sure that they're only in there once.
Very well. The defendant is to be fingerprinted, 30 days to appeal. Please file the appeal promptly.
Your Honor, may I approach the clerk? We have put I have written on the letters that I had, so we've put a composite together and I've shown it to Mrs. Kappelman, who has no objection to that.
Please place the sticker on them so that way they can be admitted.
No objection.
We are in recess.
Checking for wild sound. Hot mic moments.
782.
Nope. That's it. So the last conversation they were having, it's always amusing when, you've just been sentenced to life without the possibility of parole. They start going, well, it's $20 administrative fee for this document, and it's $18. I mean, I know it's part of the process, but it just seems kind of wacky. Interesting, though, in terms of money, you may remember days ago when we started this sentencing, and 2 hours and 15 minutes seems like kind of a long period. But anyway, I feel like I've done life. So Ms. Kappelman asked for $723,123.68 in restitution for the cost of prosecution of the case. You heard the court at the end reserve 60 days to have a hearing on that issue. I've got to do some research. I can't remember what happened in Charlie's case. Clearly, they did the same thing. If anybody remembers, pass that along. I just don't remember what was done there. In most cases, the defense, just says, look, my client is penniless. And that may have something to do with why in the pre-sentence report, the investigation report, they were so certain to make it clear that she had no money, that she had only Social Security, and therefore, hey, we can't help you with that. That could have been laying the groundwork for any sort of restitution that they were going to impose on this case. It's possible. Speaking of Social Security, I saw something fly by, somebody saying, well, wait a minute, if you're convicted, you don't get Social Security, right? That's true. But remember all these bills I've talked about that I've gotten in my hot little hands, came before sentencing. What happens at sentencing? What's going on there in the courtroom? Who's scrambling around? What the hell's happening there? We're getting some free overtime here. There's Zellman talking to Harvey, maybe setting up the first appointment. Interesting. I don't know what was happening there, but it was kind of a weird little dash. Anyway, what was I talking about? We're talking about the restitution issue. Oh, the Social Security. She wasn't convicted, right? Remember, first starting today, I said, look, what's the deal? Why sentencing so important? It triggers, you heard the judge say, 30 days to file appeal. Yep, we talked about that. But it also means she is now officially convicted. Before, she was found guilty by a court and by the jury. Now she's convicted. Now the Social Security will stop. So I'm not worried about whether she's going to have enough for phone calls. I'm pretty sure she's going to be just fine. But as a taxpayer whose taxes ultimately funnel into the Social Security world, we're saving money, saving some money here. Why not save tax dollars everywhere you can? So, and I'm as soon as I sign off here, I'm going to make my request to Leon County to get the latest body cam, see if I can get that from them, and then perhaps some more phone logs, because again, I'll check with the clerk to find out what the normal process is for them in terms of transitioning folks. You know, Department of Corrections has their own schedule. They will now get the paperwork. Here you go. Here's another piece of meat for you to run through the system, and they'll take a look, figure out where they're going to send her. They'll look at and listen to the court's recommendations, right? They're going to say, okay, well, there may be the goal of the Department of Corrections, despite what you may see on some TV shows, is not to create drama within the prison. There's plenty, right? There's plenty. Oh no, I'm blurry again. Oh my gosh. It's got to be storm related or something like that. I'll make this quick because we're going to wrap up and we're going to come back at 6 o'clock. But anyway, they'll do their thing. It could take a few days before they find a spot for her. They knew this was coming, so maybe they've already got a lot of it set up. Anyway, and she'll be on her way. But there's going to be, I think, some body cam from today's events, and I'm going to see if I can get that for you. Obviously, if I do, when I do, I will share that. We may talk a little more about the phone log later today. Maybe we'll do that in a separate little feature just to get on. I want to get some help on some of the names here that I see come up so many times. And in my research, I can't peg them to anything other than maybe just friends of the family. And maybe that's all there is to it. There was one from an attorney in California. I won't give the name now. The name is unusual, so I'm 99% sure it is this person. Been an attorney forever. His bar number starts with 45, just to give you a sense. He has 5 numbers in his bar number. I have 6. And I've been at it for 35 years. So this guy's got to be like 80 years old. But he got one phone call, and he is no longer practicing in California. And I looked for the reason. They're pretty straightforward. 1 year he didn't pay his dues. 1 year he didn't fill out his continuing education, right? Which is a pain in the ass that all attorneys need to do. In theory, it's great. In practice, it's, come on. Anyway, that one person got one call. I found that one to be very interesting in its aberration from everything else. It was an attorney, but retired, so maybe just a friend in California. Anyway, so we're going to wrap this up from here, give you a chance to take a breath before we circle back at 6 o'clock. Missy, I think we have everybody being shuttled, portaled over to the new one. I'm assuming so. Let's see if there's anything here that I missed. I think I got to the questions. Again, thanks to all for hanging out and for the questions. It was probably more drama than we expected. Ultimately, the result was what we expected. And we'll talk about it a little bit more when Linda Kenney Baden circles back with us at 6 o'clock. And we'll also have some Kelsey Fitzsimmons. We haven't heard yet. I wish I had an answer for you. I'll double check one more time, but the court's closed today. This Columbus Day quasi holiday. So nothing happened at the SJC unless they were working on the holiday. I doubt. Maybe something as early as tomorrow in the Kelsey Fitzsimmons case, because the Commonwealth has responded. It's out there. If you haven't seen it, we'll hit some of the high points. But something I found more important than that, it's all based on this hearing that took place on September 11th. And so I've pulled that audio again. I've enhanced it. Put the subtitles in, tried to make it as understandable as possible. It's pretty darn clean. And what you need to hear, what you will hear, is how this judge was a total asshole that day, looking for a reason to put Kelsey Fitzsimmons back in jail. And as you see in the opposition by the Commonwealth, that tone is regurgitated, even though on the day of the hearing that the Commonwealth did nothing. The guy was a tool, and I'm going to give you his name so you don't forget it, because he was useless. And now comes out as, oh, well, hey, we wanted to, do the right thing at all times. And his name is James Gubitosi. What a useless wad. Anyway, we're going to listen to that audio again, bits and pieces of it for sure, and you'll see how this judge was just out of control. That's all I can tell you. All right, so we'll see you soon at 6 o'clock, back with more Justice Served TV. Good to have you along today. Very interesting outcome, and we'll see you.